Contract Act, Section 4, Communication when complete. Section 4 of the Indian Contract Act, 1872 lays down the rules for determining when the communication of a proposal, acceptance, and revocation becomes legally complete, thereby deciding when contractual rights and obligations arise. It establishes the exact stage at which communication takes legal effect, reducing disputes over offers, acceptances, and revocations while ensuring certainty and fairness in contractual dealings. 1. Purpose of Section 4. The primary purpose of Section 4 is to determine when the communication of a proposal, acceptance, and revocation becomes legally effective. By fixing the stage at which communication is complete, the section reduces disputes and ensures certainty in the formation of valid contracts. 2. Completion of communication of a proposal. According to Section 4, the communication of a proposal is complete only when it comes to the knowledge of the person to whom it is made. Merely sending an offer is not enough, as it becomes legally effective only when the intended recipient receives and becomes aware of its contents. 3. Meaning of comes to the knowledge. The expression, comes to the knowledge, means that the proposal has reached the person for whom it is intended and that the person has an opportunity to become aware of it. For example, an offer sent by email or courier is complete only when it reaches the recipient, making knowledge of the proposal the foundation of a valid acceptance. 4. Completion of communication of acceptance as against the proposer. Section 4 provides that the communication of acceptance is complete against the proposer when the acceptance is put into the course of transmission beyond the control of the acceptor. This is known as the postal or dispatch rule, under which the proposer becomes legally bound once the acceptance is properly dispatched through an authorized mode of communication. 5. Completion of communication of acceptance as against the acceptor. The proposer becomes bound when the acceptance is dispatched, but the acceptor becomes bound only when the acceptance comes to the knowledge of the proposer. Section 4 creates different points of completion for each party, balancing their interests by protecting the acceptor after dispatch while ensuring the proposer receives the acceptance. 6. Importance of different rules for acceptance. The distinction between completion of communication against the proposer and the acceptor promotes certainty and protects parties acting in good faith. Once acceptance is dispatched, the proposer cannot avoid liability merely because it is in transit, while the acceptor is bound only after the proposer receives knowledge of the acceptance. 7. Completion of communication of revocation as against the person making it. Section 4 provides that the communication of revocation is complete against the person making it when it is put into the course of transmission beyond that person's control. Once the revocation has been properly dispatched through an appropriate mode of communication, the sender cannot withdraw or alter it. 8. Completion of communication of revocation as against the person receiving it. The communication of revocation becomes complete against the person to whom it is made only when it comes to that person's knowledge. A proposal or acceptance is effectively revoked only after the recipient receives and becomes aware of the revocation, ensuring that parties are not affected by unknown communications. For more details, contact us.